Section 28. Holding out. 1. Anyone who by words spoken or written or by conduct represents himself, or knowingly permits himself to be represented, to be a partner in a firm, is liable as a partner in that firm to anyone who has on the faith of any such representation given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit. 2. Where after a partner's death the business is continued in the old firm name, the continued use of that name or of the deceased partner's name as a part thereof shall not of itself make his legal representative or his estate liable for any act of the firm done after his death. Section 29. Rights of transferee of a partner's interest. 1. A transfer by a partner of his interest in the firm, either absolute or by mortgage, or by the creation by him of a charge on such interest, does not entitle the transferee, during the continuance of the firm, to interfere in the conduct of the business, or to require accounts, or to inspect the books of the firm, but entitles the transferee only to receive the share of profits of the transferring partner, and the transferee shall accept the account of profits agreed to by the partners. 2. If the firm is dissolved or if the transferring partner ceases to be a partner, the transferee is entitled as against the remaining partners to receive the share of the assets of the firm to which the transferring partner is entitled, and, for the purpose of ascertaining that share, to an account as from the date of the dissolution. Section 30. Minors admitted to the benefits of partnership. 1. A person who is a minor according to the law to which he is subject may not be a partner in a firm, but, with the consent of all the partners for the time being, he may be admitted to lice benefits of partnership. 2. Such minor has a right to such share of the property and of the profits of the firm as may be agreed upon, and he may have access to and inspect and copy any of the accounts of the firm. 3. Such minor's share is liable for the acts of the firm, but the minor is not personally liable for any such act. 4. Such minor may not sue the partners for an account or payment of his share of the property or profits of the firm, save when severing his connection with the firm, and in such case the amount of his share shall be determined by a valuation made as far as possible in accordance with the rules contained in Section 48. Provided that all the partners acting together or any partner entitled to dissolve the firm upon notice to other partners may elect in such suit to dissolve the firm, and thereupon the court shall proceed with the suit as one for dissolution and for settling accounts between the partners, and the amount of the share of the minor shall be determined along with the shares of the partners. 5. At any time within 6 months of his attaining majority, or of his obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, such person may give public notice that he has elected to become or that he has elected not to become a partner in the firm, and such notice shall determine his position as regards the firm, provided that, if he fails to give such notice, he shall become a partner in the firm on the expiry of the said 6 months. 6. Where any person has been admitted as a minor to the benefits of partnership in a firm, the burden of proving the fact that such person had no knowledge of such admission until a particular date after the expiry of 6 months of his attaining majority shall lie on the persons asserting that fact. 7. Where such person becomes a partner, his rights and liabilities as a minor continue up to the date on which he becomes a partner, but he also becomes personally liable to third parties for all acts of the firm done since he was admitted to the benefits of partnership, and b. His share in the property and profits of the firm shall be the share to which he was entitled as a minor. 8. Where such person elects not to become a partner, his rights and liabilities shall continue to be those of a minor under this section up to the date on which he gives public notice, b. His share shall not be liable for any acts of the firm done after the date of the notice, and c. He shall be entitled to sue the partners for his share of the property and profits in accordance with subsection 4. 9. Nothing in subsections 7 and 8 shall affect the provisions of Section 28. Chapter 5. Incoming and outgoing partners. Section 31. Introduction of a partner. 1. Subject to contract between the partners and to the provisions of Section 30, no person shall be introduced as a partner into a firm without the consent of all the existing partners. 2. Subject to the provisions of Section 30, a person who is introduced as a partner into a firm does not thereby become liable for any act of the firm done before he became a partner. 32. Retirement of a partner. 1. A partner may retire, with the consent of all the other partners, b. in accordance with an express agreement by the partners, or c. where the partnership is at will, by giving notice in writing to all the other partners of his intention to retire. 2. A retiring partner may be discharged from any liability to any third party for acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm, and such agreement may be implied by a course of dealing between such third party and the reconstituted firm after he had knowledge of the retirement. 3. Notwithstanding the retirement of a partner from a firm, he and the partners continue to be liable as partners to third parties for any act done by any of them which would have been an act of the firm if done before the retirement, until public notice is given of the retirement. Provided that a retired partner is not liable to any third party who deals with the firm without knowing that he was a partner. 4. Notices under subsection 3 may be given by the retired partner or by any partner of the reconstituted firm. Section 33. Expulsion of a partner. 1. A partner may not be expelled from a firm by any majority of the partners, save in the exercise in good faith of powers conferred by contract between the partners. 2. The provisions of subsections 2, 3, and 4 of Section 32 shall apply to an expelled partner as if he were a retired partner. Section 34. Insolvency of a partner. 1. Where a partner in a firm is adjudicate and insolvent, he ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is thereby dissolved. 2. Where under a contract between the partners the firm is not dissolved by the adjudication of a partner as an insolvent, the estate of a partner so adjudicate is not liable for any act of the firm and the firm is not liable for any act of the insolvent, done after the date on which the order of adjudication is made. Section 35. Liability of estate of deceased partner. Where under a contract between the partners the firm is not dissolved by the death of a partner, the estate of a deceased partner is not liable for any act of the firm done after his death. Section 36. Rights of outgoing partner to carry on competing business. 1. An outgoing partner may carry on a business competing with that of the firm and he may advertise such business but, subject to contract to the contrary, he may not a. Use the firm name, b. Represent himself as carrying on the business of the firm, or c. Solicit the custom of persons who were dealing with the firm before he ceased to be a partner. 2. Agreement in restraint of trade. A partner may make an agreement with his partners that on ceasing to be a partner he will not carry on any business similar to that of the firm within a specified period or within specified local limits, and, notwithstanding anything contained in Section 27 of the Contract Act, 1872, such agreement shall be valid if the restrictions imposed are reasonable. Section 37. Right of outgoing partner in certain cases to share subsequent profits, where any member of a firm has died or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement of accounts as between them and the outgoing partner or his estate, then, in the absence of a contract to the contrary, the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of the profits made since he ceased to be a partner as may be attributable to the use of his share of the property of the firm or to interest at the rate of 6% per annum on the amount of his share in the property of the firm. Provided that where by contract between the partners an option is given to surviving or continuing partners to purchase the interest of a deceased or outgoing partner, and that option is duly exercised, the estate of the deceased partner, or the outgoing partner or his estate, as the case may be, is not entitled to any further or other share of profits, but if any partner assuming to act in exercise of the option does not in all material respects comply with the terms thereof, he is liable to account under the foregoing provisions of this section. Section 38. Revocation of continuing guarantee by change in firm. A continuing guarantee given to a firm, or to a third party in respect of the transactions of a firm, is, in the absence of agreement to the contrary, revoked as to future transactions from the date of any change in the constitution of the firm. Chapter 6. Dissolution of a firm. Section 40. Dissolution by agreement. A firm may be dissolved with the consent of all the partners or in accordance with a contract between the partners. Section 41. Compulsory dissolution. A firm is dissolved, a. By the adjudication of all the partners or of all the partners but one is insolvent, or b. By the happening of any event which makes it unlawful for the business of the firm to be carried on or for the partners to carry it on in partnership. Provided that, where more than one separate adventure or undertaking is carried on by the firm, the illegality of one or more shall not of itself cause the dissolution of the firm in respect of its lawful adventures and undertakings. Section 42. Dissolution on the happening of certain contingencies, subject to contract between the partners. A firm is dissolved, a. If constituted for a fixed term, by the expiry of that term, b. If constituted to carry out one or more adventures or undertakings, by the completion thereof, c. By the death of a partner, and d. By the adjudication of a partner as an insolvent. Section 43. Dissolution by notice of partnership at will. 1. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partners of his intention to dissolve the firm. 2. The firm is dissolved as from the date mentioned in the notice as the date of dissolution or, if no date is so mentioned, as from the date of the communication of the notice. Section 44. Dissolution by the court. At the suit of a partner, the court may dissolve a firm on any of the following grounds, namely, a. That a partner has become of unsound mind, in which case the suit may be brought as well by the next friend of the partner who has become of unsound mind as by any other partner. B. That a partner, other than the partner suing, has become in any way permanently incapable of performing his duties as partner. C. That a partner, other than the partner suing, is guilty of conduct which is likely to affect prejudicially the carrying on of the business, regard being had to the nature of the business. D. That a partner, other than the partner suing, willfully or persistently commits breach of agreements relating to the management of the affairs of the firm or the conduct of its business, or otherwise so conducts himself in matters relating to the business that it is not reasonably practicable for the other partners to carry on the business in partnership with him. A. That a partner, other than the partner suing, has in any way transferred the whole of his interest in the firm to a third party, or has allowed his share to be charged under the provisions of Rule 49 of Order 21 of the First Schedule to the Code of Civil Procedure, 1908, or has allowed it to be sold in the recovery of arrears of land revenue or of any dues recoverable as arrears of land revenue due by the partner. F. That the business of the firm cannot be carried on save at a loss, or G. On any other ground which renders it just and equitable that the firm should be dissolved. Section 45. Liability for acts of partners done after dissolution. 1. Notwithstanding the dissolution of a firm, the partners continue to be liable as such to third parties for any act done by any of them which would have been an act of the firm if done before the dissolution, until public notice is given of the dissolution. Provided that the estate of a partner who dies, or who is adjudicate and insolvent, or of a partner who, not having been known to the person dealing with the firm to be a partner, retires from the firm, is not liable under this section for acts done after the date on which he ceases to be a partner. 2. Notices under subsection 1 may be given by any partner. Section 46. Right of partners to have business wound up after dissolution. On the dissolution of a firm, every partner or his representative is entitled, AC against all the other partners or their representatives, to have the property of the firm applied in payment of the debts and liabilities of the firm, and to have the surplus distributed among the partners or their representatives according to their rights. Section 47. Continuing authority of partners for purposes of winding up, after the dissolution of a firm, the authority of each partner to bind the firm, and the other mutual rights and obligations of the partners, continue notwithstanding the dissolution, so far as may be necessary to wind up the affairs of the firm and to complete transactions begun but unfinished at the time of the dissolution, but not otherwise. Provided that the firm is in no case bound by the acts of a partner who has been adjudicate insolvent, but this proviso does not affect the liability of any person who has after the adjudication represented himself or knowingly permitted himself to be represented as a partner of the insolvent.